Maryland, unfortunately, is one of only 5 states in the entire country that has adopted or adopts the principle or doctrine of contributory negligence. So, contributory negligence is a legal principle that basically says the following: that if you're even 1% at fault for your own accident, even if the other driver or person was 99% at fault, in Maryland, you lose. You get nothing. It's a very, very difficult principle to overcome in many situations, and a very unfair principle, and one that we've been trying to get changed in Maryland for a while now. And again, as mentioned, there are only 5 states left in the country that have that rule, but unfortunately, Maryland is one of them. However, it is so important and critical for people to not self evaluate whether or not they think this rule applies to their case. Um, the question isn't whether or not somebody was negligent, right? There can be many situations where somebody would engage in behavior that may seem to be negligent, but may not, in fact, have contributed to how the accident happened. And as experienced and skilled personal injury attorneys, we frequently evaluate cases where, on the surface, it may seem like somebody's conduct was negligent, and if they're 1% at fault, they lose. But on closer inspection and actually taking the time to do a deep dive into the facts of the case, we're able to come up with a legal theory where that behavior didn't, in fact, constitute negligence, or sometimes more importantly, that that behavior didn't contribute to how the accident happened. Let's say that you're driving on a main road and somebody has a stop sign and they merge in front of you. It would seem on the surface that it was their fault, but let's say that you're doing 60 in a 55, and you look at that and you go, well, I guess I was speeding, and maybe that makes me negligent. And oh boy, based on the 1% rule, maybe it's not worth even pursuing. There's a way to make an argument to say, look, even though you're doing 60 and a 55, that person should have been able to see you. That a 5 mile an hour difference isn't going to affect their ability to see a vehicle coming. It's not like you were doing 80 in a 55, and that driving over the speed limit, even if it was negligence, didn't contribute to how the accident happened. That 5 mile difference was not a factor that led to the accident. The accident would have happened, in theory, whether you were doing 55 or 60. And so that's just an example of a situation where we would make an argument, or potentially try to make an argument, that would help us overcome contributory negligence. And then we're able to pursue a claim frequently successfully, where on the surface, again, it may seem like somebody was at least 1% at fault. So there's no downside to reaching out to us here at Dubo Law to have us evaluate whether or not we think contributory negligence may apply in your case. If we decide that it does, the consultation is free, and there's no cost to you. And if we decide we think there's a way to overcome it, and we think we can help you, we don't get compensated until the end of the case anyway. And so it's dependent on the outcome. And there's no risk, there's no downside to having one of our attorneys evaluate your claim, because the reality is that even with that difficult a principle to overcome, there are many situations where we have found a way to overcome it to the benefit of our clients.